Alright, welcome to this video capsule that is going to provide a preliminary introduction to the issue of litigation privilege. Litigation privilege is a really important privilege that is designed to provide protection to people who are trying to advance their interests in litigation. In a nutshell, this privilege allows people to have a zone of privacy so that when they are investigating and defending themselves in the pursuit of litigation, the other side can't come in and get all their private files. Litigation privilege is what stops opposing parties from getting access to things you are doing behind the scenes to investigate and make sure you put your best foot forward in litigation. Let's dig right into it. So a good way to start thinking about litigation privilege is actually to think about what it's not, which is legal advice privilege, or solicitor-client privilege if you prefer. And 20, 30 years ago, these two privileges were thought of as the same, and that litigation privilege was just a subset of legal advice privilege. But I'm going to show you why these two privileges are now completely distinct. The truth of the matter is, they both protect against similar kinds of interests, your ability to go and defend yourself, but they do so in very different ways. And a good thing to keep in mind going forward is that legal advice privilege is the most powerful privilege there is in Canada, and it's a very important privilege that is protected with the strongest possible safeguards. Litigation privilege is important and certainly has been recognized as such, but not quite as important, and the reason should be clear when we start looking at these examples. And this right here is a really good example, a basic example of legal advice privilege. And look what we've got here. We've got a client who goes to a lawyer and does this to advance their legal interests. When they need assistance, they have to be able to speak freely. So this is the ultimate protection that the legal system provides. You go and speak to your lawyer, they can give you your advice. Now, solicitor-client privilege is tremendously important, but as you can see from this example, it's actually incredibly narrow. Okay? It only protects your ability to communicate directly with your lawyer. And while there are some expanded versions of this, it's really designed to only protect where you send through a representative. So if I send something through the mail, for example, that's still protected. Or if I speak to an assistant of the lawyer, that's still protected. But the fact that it includes representatives simply means that when you are speaking to your lawyer in any way possible, you are still protected by legal advice privilege. And the basic idea and the rationale of that privilege is, I need to be able to get legal advice, my lawyer needs to be able to help me, and anything we say to and from each other needs to be protected so that no one else can get their hands on it ever. Great privilege, very important, but as you'll see, there is one sort of intrinsic design flaw that doesn't allow you to protect yourself and access your legal rights as fully as you otherwise would, and for this, we need the protection of a second privilege, litigation privilege. So if you think about it, legal advice privilege was really important, and in the last example I had Johnny going to see his lawyer and telling him he thinks what he did was a fraud. So he's obviously been charged with fraud, and there's no question that when he confesses all the facts to his lawyer, whatever he says to his lawyer is protected by legal advice privilege. There's no question of that. But that's not necessarily enough. If Johnny is going to be able to defend himself against the claim made by the state, or if you prefer, you can think of this as a civil transaction in which he's being sued for fraud, it really makes no difference, he needs to be able to get the most out of his lawyer. But his lawyer needs to be able to do the most he can to figure out Johnny's best course of defense in litigation. Think about it right now. We're only in litigation. So what he does is he hires a third party, an accountant. So unfortunately, the information comes up badly. The accountant says, no, this doesn't look good, it's a fraud. Okay, great. What do we do with this information? If this was, if it's not privileged, it's ordinarily admissible because it's clearly relevant. You have an expert who's looked over the case, and let's assume his evidence is otherwise admissible. I don't want to get too caught up in particularities. The question is it protected? Well, this is not a communication between lawyer and client, and it's clearly not done for the rationale of legal advice privilege, which was to be able to understand how to, access legal information. That's not what it is. It's designed to help the lawyer prepare for litigation by investigating their case fully. And so it does not come within the boundaries of legal advice privilege, but I can tell you one thing, it's definitely privileged by litigation privilege. And this is based on the idea, emphasized very recently by the Supreme Court, that litigation privilege allows you to facilitate investigation and preparation of a case. So in other words, we don't just have a lawyer privilege. I mean, the reason, by the way, in case you're wondering why lawyer-client privilege is so restricted is because you can't just have a lawyer privilege. If lawyer-client privilege wasn't restricted to lawyer-client communications, you'd have lawyers doing everything, and then the state could never investigate, and neither could other parties. So lawyer-client privilege is restricted for some good reasons, but litigation privilege allows parties and lawyers, and I should emphasize very clearly, you don't need to be a lawyer to engage litigation privilege. It ensures the efficacy by maintaining a protected area to facilitate investigation. It's good for parties too. Anybody doing their own work to examine the case is also protected by litigation privilege. So if you're making notes on documents, if you are investigating by speaking to an expert, whatever you do to advance your case, so long as that's what you're doing, it needs to be protected by litigation privilege. Essentially, as the Supreme Court says here, we feel the best way to maintain the efficiency of the adversarial process is to let people examine and explore their cases fully without worrying that the other side is going to come in and grab it. That's not good. We don't allow that to happen, and we do that by creating litigation privilege. So it's interesting to compare lawyer-client privilege with litigation privilege, because what you can see here is that litigation privilege allows for a much broader scope of relationships. I mean, this is very narrow. I like to say that legal advisor's privilege is very narrow, but within the scope of the relationship, it's very broad, very powerful. Litigation privilege is the opposite. It's extremely broad. I mean, look at it. Any work done by a lawyer or a client on their own is potentially covered. Clients meeting with experts or specialists, covered. Lawyer meeting with experts or specialists, covered. All these things are covered. But the difference between litigation privilege and legal advisor's privilege is that litigation privilege is designed to advance your interests in litigation. That's it. So therefore, whenever you're just meeting with an investigator not for litigation, it's not protected. Similarly, a lawyer doing work in their office, assuming it's not covered by legal advice privilege, is also not protected. And if I make notes on a document and I'm not preparing for litigation and I'm just some business owner, that's not protected either. In fact, that is the biggest way of restraining the privilege. And this is the key. I just told you why we need litigation privilege. Well, litigation privilege will only apply when the material in question was prepared for the dominant purpose of real or apprehended litigation. And the reason for this, by the way, and the reason why it's such a high standard is, in this day and age, when we have two parties who are fighting over a particular dispute, the basic idea is that it's better if both sides have to turn everything over to each other. By and large, we want parties to proceed in a spirit of openness so we can see who has the best case. It's not meant to be about legal maneuvering, it is, but not entirely. It's designed to let parties see who has the merits and settle if possible. Well, litigation privilege is an exception to this. It's designed to say, okay, we're going to force you to turn everything over, but where you can show that you did something really only or very strongly, mostly, the dominant purpose to advance your case in litigation will allow you to keep that private, but nothing else. And if you can imagine, this is a heavily litigated area of law, because if you can think about it, both sides, when they're involved in litigation, they want full access to the other side's case because it's useful to know what the other side have. But on the other hand, the other side wants to hold back. They want to say, no, you can't have access to this material, and the reason for that is because, again, it's useful to keep these things secret. So there's a lot of litigation over litigation privilege, and a lot of that comes down to what was the dominant purpose of creating this material. And just to put it in very concrete terms to show how complex this can get, and I'm not going to give answers here, it's really just to show you, really how this happens. Let's say you have a case and this lawyer represents a corporation that's responsible for, a gas factory, and there's a major explosion takes place, and something looks really bad. So something bad has happened. So the lawyer wants to hire an expert immediately, and the truth of the matter is, they probably want that expert to do a couple of things. One is to find out what went wrong, so they can improve safety. Like, they need to immediately correct what went wrong to fix it. But on the other hand, there's no question, they know that litigation is coming down the road. Now, I hope you can see what the nature of the problem is. This expert is the first person on the scene, and they're going to prepare an awesome report that has all the details that any person involved, in suing this corporation would want. The question is, can they have it? And believe me, that is a very heavily contested issue time and time again in the courts. And the reason is because on one hand, the courts want to protect it and encourage parties to prepare for litigation fully. That on the other hand, this is the best possible information there is, and openness and disclosure in the modern era sort of suggests that we should allow people to have access to the information. I can't resolve this problem here, but I want you to understand the nature of the problem and really what is going on when parties are fighting over litigation privilege. So a couple of final points to keep in mind with litigation privilege versus legal advice privilege. One is that legal advice privilege is forever. Remember, I told you it's a much stronger privilege. If I go speak to a lawyer, anything I say to get legal advice is protected for the rest of my life and beyond. But litigation privilege isn't. Remember, it's only designed to allow you to have a zone of privacy. So once the litigation is over, you don't need the privilege anymore. And this can be really important. A good example of when this really matters is when the government is involved in litigation privilege. Like the government may be defending a claim and may very validly create expert materials for litigation privilege. And, if somebody wants to access that through access to information legislation, they'll be refused when the litigation is ongoing. But once that litigation is over, that's free, fair game. It's no longer privileged. The privilege has ended. And I should just add, it's a very complex area. I may ultimately make another capsule on it one day. What is the end of litigation? Well, the end of litigation, courts are willing to recognize that sometimes litigation may spawn several actions, like someone may sue you for related things. So there's a question of whether or not litigation has truly ended when somebody's trying to get access to that material. And finally, let's talk very briefly about exceptions to litigation privilege. And what I can tell you for sure is that they're still being developed. And the reason is because the courts are still trying to finesse the extent to which legal advice privilege and litigation privilege are different. One thing we know for sure is that all the main exceptions to legal advice privilege, so full answer in defense, for example, innocence at stake, and the crime-fraud exception, those exist for litigation privilege as well. But we also know that other exceptions may be identified in future. And Lizotte versus Aviva Insurance, a very interesting case, the Supreme Court rejected the idea of a general exception. They said, we're not going to have a general exception that's based on need. We're not going to have that. We're going to have specific exceptions in future. And all I'm going to say about that to finish up is it's great that they said that. It provides a lot of certainty. We're going to have narrow classes, but I can tell you that this is going to cause problems down the road. There are cases for which litigation privilege may validly apply. The example of the gas factory I talked about where, a gas refinery blowing up or something, there may well be preparing for litigation, but sometimes that first information that is legitimately falls in is the best information available. And some courts have talked about this idea of a general exception based on high level of need. And keeping it secret would really disadvantage the other party. Supreme Court's rejected that so far, so it'll be interesting to see what happens with this in future. For the moment, what we are seeing is that the privilege is taken very seriously, and it's very hard to get through it. Exceptions will be narrow, perhaps based on things like urgency, because litigation privilege can apply across the board to a range of parties. And sometimes you may need that information to actually address a problem that needs to be resolved beyond this particular litigation. So these are things that are being mooted in the jurisprudence, but they're still going to need to be examined moving forward into the future. Important to remember, litigation privilege is a pretty new privilege, and to the extent that it's been divorced from legal advice privilege, and things are still being mooted by the courts going forward. In any event, that's enough to get you started. This is a topic that I may develop supplemental capsules for because some of these issues really complex and still in the process of being litigated. Have a great day.